Hello, everyone. Yes, navigating the I-140 Immigrant Petition. And this is going to be the second episode with, of course, none other than our very own Attorney Prashant Dubey. He's going to join us again. This is going to be the second episode because the last episode, the last Friday, we spoke about it and we couldn't cover all of it because it's such a huge topic. So I hope that all folks out there are very excited and stay tuned and be with me. That's right. I hope you're eager to know about the I-140 Immigrant Petition even more. And I hope that you already watched the first episode on this we had with none other than Attorney Prashant Dubey. So please help me welcome him back to enlighten us more about the I-140 Immigrant Petition. So welcome back, Attorney Prashant Dubey. Thank you for joining us once again.
Yep. Thank you, Nipa, for hosting today's episode and the higher IT team for again allowing me to continue, this employment-based series of immigration webinars that really we've been doing since last December, I believe. Thank you to Zayed in the background, who's running the operations and making sure everything is good. I think I always run into some issues with my camera, so I appreciate you always correcting me on that. So in last week's episode, we spoke at length about the I-140 process, right? And just to give everybody a recap in terms of the other episodes we've conducted in this series, really, this I-140 process starts with the prevailing wage determination. And I'm not going to talk about this at length because I think people can go back and watch some of the other videos. But the prevailing wage determination is nothing other than taking the skill sets, job requirements, education requirements that an employer is willing to sponsor someone for, and asking the Department of Labor to come back with a prevailing wage, which basically says that based on the information you've provided, the job requirements, the education requirements, these specific skills, maybe there's a language requirement, based on all of these details, this is the minimum wage that you need to be paying this individual. And that's really meant to protect domestic workers and foreign workers alike, just to make sure that people are being appropriately compensated for the position that they're being sponsored for. Now, once the prevailing wage determination comes back, and that can take 3 to 6 months, and some crazy length of time can be about a year. But once that comes back, you can start the PERM process, right, which is the 9089. And basically, the PERM entails doing recruitment, and recruitment is basically saying to the Department of Labor that, hey, we've gone out and posted on newspaper ads, on radio ads, we've posted on an online job board, and we can't find anyone else with this specific skill set, with this specific education, and somebody that can do these job responsibilities. We can't find anyone else to do this job from the US labor market, right? And then you're eligible to file your PERM application. Once that recruitment period plus the 30-day quiet period is completed. And so once you file the 9089, you're again kind of just waiting because the perm can take about a year to get approved and issued. And so once the perm is issued, what then an individual is able to do, or really an employer is able to do, is you get to the I-140 stage, which is the second half of the I-140 is the subject of today's webinar. But at the I-140 stage, you can do this in premium processing. So you're no longer waiting a year, 6 months, crazy amounts of time to get it approved. You can do it in premium, which means you'll get a response back in 15 days, unless there's some sort of request for evidence, and sometimes that does happen. But essentially, once the perm is approved, it's valid for 180 days, right? And within that time frame, the I-140 petition can be filed. And the I-140 petition is typically, you're telling USCIS that, hey, look, this is the specific employment-based category, EB2, EB3, that we would like to sponsor this individual for. So at that stage, you're providing the education documents, degree certificates, education evaluation. You're providing the prevailing wage determination and the PERM that was issued. You're providing employment verification letters from previous employers, where you're showing that, hey, this individual obtained these skill sets, prior to joining employment with myself, or with us as an employer, so that you can show that, it wasn't you that trained this individual to do this job. Because if an employer says, hey, they gained all of this work experience with us, then the problem becomes USCIS looks at that and says, well, why can't you just train somebody else in the US labor market to do that job? Why do you need this specific individual, right?
Mhm.
um, at that stage, you must also show the employer's ability to pay the wages, right? So through tax returns, financial audit reports, whatever that might be, you have to be able to show that whatever the prevailing wage is, you have the ability to pay those wages. And so, in a nutshell, that is kind of end to end, how the process unfolds for the employment based categories up until the I-140 stage.
Absolutely. And friends, we are going to talk a lot more and at length, mini topics about the subtopic. So it's going to be a fun time today as well, a good session with attorney Prashant Dubey. And I hope you are very excited for this one. But also, for folks out there who just joined us, who this is my first episode, at the fifth episode with attorney Prashant Dubey. I think people who have joined us would love to know you better. So if you could just tell us a little bit also how you were awarded the best attorney as well in 2023. Tell us about yourself a little bit.
Yeah, so I am based out of Washington, D.C. And it's funny because D.C. is, I think it's a catch-all phrase for a lot of the suburbs surrounding D.C., but really I'm based out of Alexandria, Virginia. So really right across the river. I live here with my family, so I've got a wife, and a 2-year-old. And so our 2-year-old, like, she keeps us on our toes, and we've been dealing with her tantrums of late. No one told us that it starts before the terrible twos, but apparently it does. And I grew up here in the US, right? So when my family moved here almost 30 plus years ago, we lived in Richmond, Virginia. And so I went to high school in Richmond, Virginia, attended college there at the University of Richmond. I moved up to Washington, D.C. for law school, and then I've really stayed ever since. And it's been a great journey, especially after starting my own immigration practice. And kind of like you alluded to, right? Silicon India, awarded us with a top 10 immigration law firm, sort of recognition. And, that's really just a testament to my clients, and the fact that they place a certain amount of trust in us, and the work we do. And it's something we pride ourselves on, right? Customer service is just so important, not only in being an attorney, but really in any business, right? Making sure you're always striving better for your clients. And so it was great to get that recognition.
Yes, absolutely. Congratulations once again. And thank you again for joining us. And folks out there, I'm Nipasa Pradhan, and this is Immigration and Jobs Talk Show. It's going to be a fun session today talking about the I-140 petition. And without further ado, let's go answer the question, which is already displayed on the screen. What are the grounds for an I-140 petition denial, and how common are they? What are the best
Yeah.
practices for filing an appeal for or a motion to reopen or consider a denied I-140 petition?
Yeah. So this is where really drafting, of the entire perm labor certification process, right? From prevailing wage determination to perm to I-140 is really critical, right? You can't really think about them as disjointed pieces of the process. They really do, step by step build upon one another. Because if you make a mistake early on, whether that's at the PWD stage, whether it's at the perm stage, it can lead potentially to a denial at the I-140 stage. And so some of the common reasons that I see a denial is, for example, the position just simply doesn't qualify for the category that you're sponsoring someone for, right? So, for example, a labor certification application might state that a position requires a bachelor's degree and that the employer will, accept a 3 years bachelor's degree to meet this requirement. That position is not going to satisfy the EB2 requirements, right? So you just made a mistake by not categorizing it correctly in the EB3 category, right? If you say that you will accept something less than a US bachelor's degree, which is a 4 year degree, then again, you won't even qualify for the EB3 category unless you can show that they are a skilled worker, right? So just making sure that you have the EB2, EB3 employment-based preference categories in mind at the very beginning, and working with an attorney, again, doesn't have to be me, can be anyone, but working with an attorney that is thinking ahead for you that, hey, look, the way we draft this application process from the beginning is really going to impact the I-140 stage 12 to 18 months down the road is extremely important, because I have seen employers that try to do it on their own, and they'll fill something out in the perm labor certification where they'll say, yeah, we'll take a master's degree, but then the skills and the job requirements don't really require a master's degree. It only requires a bachelor's degree. So USCIS is going to question that, and it could lead to a denial. Other situations can be when the beneficiary or the employee simply doesn't qualify for the position, right? And so sometimes that can be you misjudged the experience requirement. Perhaps you didn't do an education evaluation at the early stages where they might have a 3 years bachelor's, but it's not equivalent to a US bachelor's. Now that's a problem, because maybe they have a 3 years, maybe that they have a 3 year bachelor's plus a certain amount of work experience, but like if the degree equivalency doesn't match up, then you're probably knocked down to an EB3 category versus an EB2 category. So those are some of the things that can pose a problem. And then the last thing that I sometimes see is the ability to pay, right? This is not necessarily an issue for some of the larger staffing consulting firms, organizations out there. But I do see it quite often with employers that may have less than 5 to 10 employees, where maybe they don't have the right financial audited documents. Maybe they don't have the proper funding to say, like, hey, when this person gets their green card, I can pay their wages. So that ability to pay requirement can sometimes be very tricky to deal with. You got to make sure your finances are solid and that your books are very clean. That you have an accountant that's doing the record keeping for you. So I'd say those are typically the top three reasons. The beneficiary simply doesn't qualify. The position maybe doesn't qualify, or even the employer's ability to pay, or where people run into issues. Now, let's say your I-140, as a petitioner, as an employer, does in fact um, get denied. There's a few different things you can do, right? You can simply reapply, right? You do need to, you'll get, if you do it in premium processing, you'll get a decision on your I-140 within 15 days. There's no limit to how many times you can reapply that I-140, so long as the perm is still valid. But when you're doing that, you really need to make sure that you're taking into account the reasons for the denial, right? So if you're sending back the same application package, you're probably going to end up getting a denial again. But if USCIS stated that, there was no evidence of your academic record, right, of your master's degree, for example, send that the second time, right? If USCIS says that there's insufficient evidence to prove your experience or your achievements or the recognition you've received, then make sure you send them next time experience letters, right? So when reapplying, don't make the mistake of like just sending the same application again. Make sure you actually address the reason for the denial. And chances are it could get approved, right? If you were missing an education evaluation, or maybe you were missing experience letters, for example. The second option, if the petition is denied, is to file what's called an I-290B, right? Let's say it gets denied and you've provided every single documentation possible, right? You provided the experience letters, you provided the education evaluations, the degree certificates, the ability to pay documents, but it still gets denied, right? You do have the option to file the I-290B within 30 to 33 days of the denial. And you essentially appeal to what USCIS has, and it is the Administrative Appeals Office. And basically, a different officer from the AAO is going to review all of the facts of your case and determine whether USCIS actually made an error in its decision, right? And so there is that option to go through the I-290B. Most of the time, what I've seen with I-290Bs is that USCIS does tend to favor the decision of the initial officer, right? Unless there's some clear USCIS error where they're saying, you didn't provide the experience letters, but in fact you did, right? Like the officer has clearly missed something, and so that's
Mhm.
another option. If you can't reapply, right, because you've already provided everything, you could always do an I-290B notice of appeal.
All right. And talking about errors, how frequent are they? I mean, on a scale of 10,
Yeah,
maybe.
yeah. I mean, I would say for employers that um, try to do this process on their own, right? Errors are
Mhm.
much more frequent, and that's where I see a lot of clients who will sometimes approach me and say, "Hey, I got this request for evidence," or I'm dealing with a perm audit. Can you help me out now with this response, right? Usually,
Right.
ones that are working with an immigration attorney um, have someone that is thinking ahead for them, right? And I would say probably like you see those types of errors like 30% of the time, right? Most employers,
Mhm.
most employees are going to be working with immigration attorneys to make sure that someone is keeping in mind the timelines, right? Someone is keeping in mind the fact that, we need to be thinking about EB2, EB3, and what those preference
Mhm.
categories look like for this specific individual at the outset, right? Not at the I-140 stage. So as long as you have that help and that strategic advisor at the very beginning, I would say most of the time it goes pretty smoothly, but I do see issues where, again, it's rare. I would say it would happen like 3 out of 10 times where an employer tries to do it on their own, and that can be a challenge for them.
All right. So definitely appeal to consult an attorney for sure. And
Yeah.
yes, we are streaming live on platforms like LinkedIn, YouTube, and Facebook at the same time. So, hello to all friends out there who have joined us. I can see comments from Rohit Kumar. Yes. Hi, this is Rohit from Canada. Hi to you from Immigration Jobs Talk Show and higher IT people, and even a Tony Prashant, I'm sure. And uh, Miraf Tedi was, if I'm pronouncing it right. Hi, this is Mira from Ethiopia. Hi, nice to meet you. Thank you for joining us. And we have a lot of questions already. So I will say that if you have any questions and you want Attorney Prashant Dubey to answer, keep commenting and we are going to take them up a little later. I have a couple of questions of my own, so we'll go through them a little bit. And, hopefully your questions will also be cleared as we go through the show. So, can we get the link of the complete video of the session? For sure, we can. Mohsin Ali in LinkedIn, he's asking, and we are going to publish this right after the live session so you can see it as a post as well. All right. So, Attorney Prashan, let's move on. And I have a second question for you. How can changes in employment, such as promotions or transfers, affect on I-140 petition? And, are there any specific strategies to handle such changes without, jeopardizing the petition?
Yeah, yeah. So
Yeah, yeah. So
one thing to
one thing
keep in
to
mind is
keep
that PERM and I-140 is a promise of a future job offer, right? And so unless you plan to be with your current employer till your priority date is current, right? And I'm speaking primarily to, let's say, folks that are, dealing with priority dates that are 10, 11 years behind, right? India, China, for example. um, you can use this process to at the very least get a priority date out of it, right? So let the perm process because you will get a priority date. And who knows which employer you're going to be with 10, 12 years down the road, but at least your priority date will vest with you. And you can always, secure that as opposed to restarting the process, right? If your new role is the same or similar one as the original position that is in your perm, then you really don't need to worry about restarting the entire process, right? And by same or similar occupation, what I mean is that, are you sponsored in the same SOC code? Do you need to use, at least the underlying skill sets? Are like 50 to 60% of them still the same? Um, are the language requirements the same? Are the education requirements the same? The specific programming languages that you need to use, like, is it still, Java and C++, or is it now Python and R, right? Which speaks more to like a data analytics versus a software engineering role. So those are the things you want to keep in mind. If you are changing fields, right? Like if you're going from IT to like HR, you need to restart your perm labor certification. But if the new job is the same or similar one as what you were sponsored for originally in the perm, chances are you're completely fine, and you don't need to restart the entire process. Um, Usually where we see this really play out is, for example, you have a software engineer that was an individual contributor. Now that individual contributor is a manager, there's some sort of IT management position out there that they've taken on. As long as the underlying skill sets are still the same, you know you still have some software engineering responsibilities, but now you're just managing a team of software engineers. That's okay, and that's an example of where your new job as an IT manager is the same or similar as the one that you were originally sponsored for as a software engineer. And that will not require to do the entire perm labor certification process. And in terms of specific strategies to handle such changes, really without making a difference to the petition, is just to keep in mind: is this the same or similar job as the one I was originally sponsored for? Again, if you're changing fields, you're changing industries, you're changing programming languages, things of that nature, chances are you need to restart the perm labor certification process again, right? So just something to be cognizant of. I have seen examples where someone was formerly in a business analyst role and then they move over to product management, right? Both have
Mhm.
intersections with information technology, but what a business analyst does and what a product manager does are two completely separate things. So if that is the type of leap you're taking, even within IT, you're changing SOC codes, you're changing job responsibilities quite a bit, then chances are you have to redo the perm. So that's how I would approach it.
All right, so check on what you have to do so that you don't have to restart the whole process. And if you're definitely changing fields altogether, you might have to restart the whole process. So, moving on to the question which is already displayed on screen, what roles does the National Visa Center play in the I-140 process, and how can applicants effectively navigate the consular processing stage that follows the I-140 approval?
Yeah, yeah. So the National Visa Center is probably something that a lot of folks have not heard of. And the reason is because a lot of individuals are already here in the United States when they are being sponsored for this I-140 petition, right? There are circumstances where people might have to leave the country, that sort of thing, and go back to their home country. But more often than not, the reason why the National Visa Center doesn't play a very big role, at least for my clients in the I-140 process, that is because they're already here in the US, they're working for their employer, they're being sponsored by their employer from here within the US, and they have
Mhm.
all the plans in the world to adjust status within the US, right? Now, let's say you're being sponsored from outside of the US, right? And that's called consular processing. So the US employer, they're going to file the I-140 petition with USCIS, and they're going to request that once this petition is
Once this
approved,
petition is
that it
approved,
be sent to the National Visa Center. And the National Visa Center sits in New Hampshire. And so essentially, once that approved petition reaches the National Visa Center, it's just going to sit there for a little bit. And the reason it there is because until a visa number becomes available to you, right? Until they have a slot available to you to actually give you a green card, they're not going to do anything else with your application, right? So once it gets to the National Visa Center, there are some requirements where they're going to ask you to upload your civil documents, right? Police clearance certificate, birth certificate, copy of your passport. They're going to have your employer fill out some sort of affidavit of support, which is similar to showing that this individual that you're sponsoring, you can actually pay their wages when they come to the U.S. You're going to have to fill out a DS-260 application and secure an interview at a consulate abroad. So the National Visa Center and the processing associated with it is typically reserved for individuals that are abroad, and their I-140 processing. It happens from within the U.S., but USCIS notifies the National Visa Center that this individual is in, let's say, a country like India or China, and once a visa is available to that individual, then your processing can continue on, and you can actually attend your visa interview, submit all the documentation, and get your green card stamped. Um, in terms of navigating consular processing, I see again, I see consular processing a lot in the family-based petitions, not necessarily the employment-based petitions, but to effectively navigate it, you have to work closely with an attorney. There are about 10 steps in the process. So if you look on Department of State website, there are 10 plus steps to navigate the consular processing, right? It starts with submitting that I-140 petition. Step 2 is National Visa Center processing. Step 3 is paying the requisite fees. Step 4 is the affidavit of support. Step 5 is submitting the financial documents, right? 6 is like submitting the online application, and then the civil documents, and then you do the interview preparation. You got to do the medical examination, and then finally you attend the interview, right? There is just so many things to keep in mind there, that for anyone that's trying to navigate it on their own, it can become very overwhelming, right? Even when you just read it on the Department of State website. So I would say work very closely with your employer, and work very closely with the immigration attorney that your employer is working with, to help you navigate this process.
For sure. And if they want to get in touch with you, Attorney Prashant Dubey, folks out there, you can write to him, Dubey at info@dubeylawoffice.com. And of course, you can visit his website as well, you know, dubeylawoffice.com. Am I right? Attorney Prashant Dubey?
That is
Awesome. So
correct.
friends
Feel
out
free to feel free to
yeah.
email me, because I do not put my phone number up for public view.
It's totally understandable, and it's good actually since you have a 2-year-old as well. So I'm sure you have family duties as well, and you have
Yeah.
some, yeah. All right, let's move on to the next question, and it's like, can an employee file multiple I-140 petitions under different categories or employers? And how does this strategy affect the overall immigration timeline and, the chances of approval as well? If you could just, yeah,
Yeah.
go through that for us.
Yeah. So absolutely, right? You can have multiple I-140 petitions under different categories, under different
Right.
employers. Absolutely. There's no problem with that. So you can have an employment-based category petition pending in EB1 if you qualify, EB2 if you qualify, and EB3 if you qualify, right? And multiple employers can file these petitions as well. So typically, where I see that become, something that's relevant for my clients is when they have initially filed the PERM labor certification, the I-140 with employer A. After it becomes approved, maybe 6, 7, 8 months later, they leave employer A, they go to employer B. So even though you carry your priority date with you, employer B must also file your perm labor certification in order to sponsor you for your green card when your priority date does in fact become current, right? So that takes care of the multiple employer, sort of part of this question. You can absolutely have multiple employers sponsor you. Now, can you be, sponsored in multiple categories? Yes, you can, right? So where I've seen that really become something that people have done is over the last year or two, there have been a lot of retrogressions in priority dates. And because of those retrogressions in the EB2, EB3 categories, a lot of individuals are trying to figure out, well, do I maybe qualify for EB1, right? And they're trying to self petition the EB1. And so in those instances, the ones that are getting approved in the EB1 category, you can port your priority date from EB2 into EB1. And you can take advantage of some of the faster processing that happens in the EB1 category because those priority dates tend to move faster, right? EB1 has such a high threshold that there's just fewer and fewer people, obviously, in those categories. So that is a strategy that folks tend to use. And leveraging that strategy, it can save you years of processing. I just had an EB1 approved for a client. He's a software engineer at Fannie Mae. And a couple of days ago, his I-140 petition got approved in the EB1 A category. And he was formerly an EB2, and he has a priority date of, I think it was September 2015, which is current in EB1, right? So instead of waiting years for EB2 to become current, he was able to port to EB1. He got it approved in EB1, and now we're going to file his 485 application, right? Like we probably sped up his green card process. According to him, when on the phone, he was like, "Now I don't need to wait 150 years to get a green card," right? I don't think it's that dire. I don't think it's that bad, but that's kind of the consensus amongst folks from India and China that like you might as well have a child here in the US, make sure they're a US citizen. 21 years later, they'll probably sponsor you faster than your priority date in the employment based petition actually becoming current, right? So that is unfortunately the state of things right now. So I think if you can effectively deploy the strategy of, you know, porting from EB2 to EB1, or potentially rating from EB2 to EB3, EB3 happens to move faster, then you can really try to save yourself some time here and get your green card quicker.
Very interesting. And I hope that, you know, all the folks out there who are applying, are getting their doubts cleared. And if you have even more further questions, write to us, comment them wherever you're watching us, whether it's Facebook, YouTube, or LinkedIn. And you may even mail them directly to Attorney Prashant Dubey at info@dubeylawoffice.com. And Attorney Prashant, we are already half an hour through, and we have a lot more questions for you. So, how does the probability provision under AC 21 impact the I-140 process, and what are the legal considerations and risks involved in, utilizing the AC 21 probability?
Yeah, yeah. So the AC 21 is really interesting, right? Because I think it becomes extremely relevant at the 485 process. AC 21 essentially allows individuals to port, their green card process to a different employer, as long as the new job with that different employer is the same or similar. That word tends to come up a lot, is the same or similar as the job in which you were originally sponsored for and your I-140 was approved in, right? And also your 485 application needs to have been pending at least 180 days to take advantage of these provisions, right? So I saw this happen a lot back in October 2020 when priority dates really moved up significantly. We had a lot of people file their 45 applications due to the progress in EB2 and EB3 priority dates. And then after 6 months of having the 45 application pending, they started thinking about changing jobs. And at this stage, Once your 45 application is filed and it's been pending at least 180 days, you don't need to refile the I-140 application. You don't need to do the perm processing again, right? And this is a very important distinction here because if previously they had changed jobs without a 485 application pending, they would need to redo the whole perm process. They would need to file the I-140 petition again with the new employer so that new employer could sponsor them, right? But by having a pending 485 for at least 6 months, that's no longer the case, right? And you can move to a new employer without having to redo that entire 2 year process of the I-140 application. Um, in terms of legal considerations, risks involved in using the portability, I would say the considerations are just making sure the timing of when you notify USCIS that you're changing jobs is appropriate, right? Typically, I recommend that within about 1 to 2 months after you've changed jobs, with after your 45 application has been pending 6 months, to file the AC-21 documents, right? Work with your employer, work with their attorney to carefully prepare the documents that are required, which says, hey, USCIS, I'm now with a new employer. Here's all the details. Here's how this new job is similar to the job that I was originally sponsored for, right? And this will help you avoid kind of like a request for evidence or a notice of intent to deny situation later on with USCIS if you proactively notify them by filing what's called a 485 Supplement J. If you proactively notify them of the change in jobs, right? I
Mhm.
think another consideration is, you know, just kind of being candid with your employer, right? Informing them that you do have a 45 application pending, informing them and being very transparent about your immigration process so that they're not
Right.
surprised later on by some sort of RFE or notice of intent to deny that might come in due to your 45 application, right? So those are some legal and non-legal considerations when it comes to AC-21 portability.
Thank you. Thank you for the tips. And folks out there, transparency is very important. So be sure that you give all the information about all your visa, the update, where you are standing on it, so that there is no problem, and you're all at the same page, on the same page. So thank you so much, Attorney Prashant Dubey, for taking us through the portability provision under AC-21 impact, the I-140 process, and also the legal considerations and what all they can do. So we have a lot more questions, but we'll just go for a short break. And folks out there, you can keep commenting your questions, and you could call me also or message me in the number 408-335-6444. And this is Nipasa Pradhan on Immigration and Jobs Talk Show. Stay tuned. We'll be back right after a short break.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, all you friends out there. This is Nipasa Pradhan on Immigration and Jobs Talk Show with none other than Attorney Prashant Dubey from Dubey Law Offices. And today we are speaking about navigating the I-140 petition and, of course, continuing the legal insights that have been revealed. This is the second episode with him under the same topic, and it's been so far so good. Thank you so much, Attorney, for taking us through all these issues that we are speaking about today.
Yeah, of course. Glad to be here. Thank you.
And moving on, in what scenarios can the I-140 petition be revoked and what are the consequences? What resource does an employee have if their I-140 is unjustly revoked by an
Yeah.
employer?
Yeah. So there are some scenarios in which an employer might consider or think about revoking an approved I-140 petition, right? They
Mhm.
might decide to revoke it due to a change in business circumstances, right? Maybe they can no longer afford, that position anymore. Maybe they're shutting down that department, that group. Number of reasons, right? Where they might think about revoking it. Another reason could be that the employee is leaving 6 months prior to, or within 6 months after the I-140 approval, right? So it's always a good rule of thumb for any employee to stay with your employer for at least 6 months following the I-140 approval. And this is to avoid any risk of revocation, right? Um, and that's kind of I would say, the bright line rule. Stay at least 6 months so that even if, you know, the employer revokes the I-140 petition, you still have the priority date that has vested for you, right? If they revoke it prior to that, you need to redo the entire perm processing all over again, right? And so that is a very critical thing, because there's so many benefits that one can get by having an approved I-140, right? You get the unlimited H-1B extensions, unlimited H-4 EADs for your spouse. So even if, they withdraw it, let's say post 6 months, it's absolutely fine. All of the benefits of an I-140 approval will still vest with you. But if it gets revoked prior to those 6 months, then you lose all of those benefits. And that's so critical. That's so important for individuals to know and understand, is like, stay with your employer for at least 180 days so that, there's nothing that you're doing that is going to force your employer to withdraw or revoke the I-140 petition. Now, in terms of, what recourse an employee has, there's not a whole lot, right? Because the I-140 petition belongs to the employer. They are the petitioner. So, withdrawing an I-140 is a complete benefit to them, and there's really no negative consequences for that. And to you really can't go anywhere and complain anywhere that your I-140 petition was revoked. It's entirely up to the employer as to whether or not they want to keep it intact, or they want to, to revoke it, and take it away from you. And typically, the instances where I do see that revocation happen the most is if an employee leaves within, those 6 months after the approval, right? They have,
Mhm.
they are under their legal right, um, and immigration rights to actually revoke it from you, without any consequence to them, and you lose all of those benefits that come with an approved I-140 petition.
Right. So, friends out there, go through it and stick by the rules, and so that you don't want to, recourse the whole process all over again. And, Attorney Prashant, what are the specific challenges faced by self-petitioners under the EB1A and EB2 NIW categories? And how do adjudication, trends for these petitions reflect current immigration policies?
Yeah, I would say, specific challenges by self petitioners, is just being able to meet the high threshold, that these employment based categories have, like you said, the EB1A or the EB2 NIW. Not only do you need to objectively satisfy 3 out of 10 criteria, but then you also must show that, you're going to be beneficial to the U.S. And you need to show that, what you've done has received national acclaim. So if you've been a top performer in your company, that's usually not enough, right? You must also show that, hey, I've had an impact to the industry. or I've had an impact to my state, or I've had an impact to the US, right? So I would say, self-petitioning typically runs into those sorts of challenges, um, in that it's just got such a high threshold that, like, you might be a great, individual performer, you might have all the accolades, your workers, your colleagues love you, but that's usually not enough, unfortunately, right? You also need to be able to show that you've had an impact to the industry, and you've got to have people that are willing to write reference letters for you. You've got to be able to show work products and project details to satisfy those requirements. Most recently, some of the trends that I've seen, and this is most likely because, we have had so many people go from EB2 or EB3 to EB1, that back in September of last year, so as recently as about 5 months ago, USCIS, they issued some guidance and said, hey guys, I know we've got these criteria, and in the past, we've been very like flexible about how we interpret them, but they actually updated their policy manual to list out examples of satisfying those criteria. And when they did that, for some of my clients, it became a little bit tougher. So I'll give you an example. One of the criteria is reviewing or judging the work of others, right? And so in the past, myself and probably other immigration attorneys, if a client had direct reports, or if the client was conducting interviews for their company, we would frame an argument and state that, hey, this individual is technically reviewing the work of others. They're reviewing their resume, their credentials, that sort of thing. And USCIS kind of updated their policy, and they said, no, that doesn't count. That is just something you are doing through the normal course of your work in your day-to-day job. We want to see what you've done in the industry, right? So ways that people can now satisfy that criteria is, for example, when they do technical reviews or health checks, for industry partners, or maybe you're reviewing conference papers or you're peer reviewing journals. So they listed out specific examples and made that threshold even higher, right? And that's because they saw the influx, of all of these EB1A applications. Another requirement that typically my clients are able to satisfy is the salary requirement. And for that, they said, hey, you guys are providing us, data from all of these different sources. These different sources are not going to suffice. You have to get your salary data from Bureau of Labor Statistics or from careeronestop.org, right? All of these different sites and databases that are sponsored by the Department of Labor, right? So they got very specific in terms of like where we can collect salary data and measure our clients against that salary data, and do they fall in the top 10% of earners, that sort of thing. So they did get a little strict, I feel, because of what I think is kind of an explosion of applications in the EB1 category.
Okay. So there's no privacy regarding the salary. Everybody's going to know how much you earn, is it?
I have to know, right? So I have to know. USCIS has to know. I gotta, and typically, the clients that do approach me tend to be in like the top 10% of earners anyway. So they're earning 250,000 dollars a year. That one's usually a requirement that's very easy to meet for them. And if you don't meet it, then there's always strategies that we can try to implement to get you there. But yes, I will get I will become privy to that information. But it all stays confidential. So
All right, all right. So, Attorney Prashant, there are so many questions today. I hope you don't mind us extending about 5 to 10 minutes after two more questions that I have. I hope
sure.
you can stay with us a little longer today.
Yep, no problem.
Thank you, thank you, thank you. So, yeah, let's go to the next question that I have for you. How does the PERM audit process work and what triggers an audit? What are the effective strategies for preparing and responding to a PERM audit?
Yeah. So the perm audit, right, at the 9089 stage, right, prior to the I-140, some of the common reasons are, you know, Well, one reason can be it's completely random, right? You just got selected for a perm audit, and that's just your luck of the draw, right? Unfortunately, there's not a whole lot that one can do about that. Um, but sometimes DOL will want to see, was the recruitment actually completed? Can you show us that this individual actually has the work experience or the education requirements that you're
Mhm.
claiming are necessary for this position? Um, some audit triggers tend to be where you're requiring a degree but no work experience, right? Where you're saying, hey, I'll take somebody with a bachelor's of computer science, with 0 years of work experience. Well, you at Department of Labor might wonder, well, why can't you go find somebody with a bachelor's of computer science from here in the US to do that job, right? Some
Right.
other audit triggers can be jobs that require less than a bachelor's degree. If there's ever a family relationship between the owner and the employer, that's going to be scrutinized. If the employer has experienced any kind of layoffs in the last 6 months, that's going to be scrutinized. Any times where you have, requirements that are not typical, right? Foreign language requirements for a software engineer, for example, that's not working with offshore teams. So those are typical kind of perm audit triggers that that can happen in terms of actually preparing for the perm audit, right? It starts with an audit notification, right? The Department of Labor officer is going to notify you, the employer, that we're auditing your file. There's some requirements that we need to shore up and that we're curious about, right? So take a very close look at that audit notification, compile the documents they're asking for, right? It might be related to recruitment efforts that are undertaken. It might be copies of resumes from applicants that applied for the job and that you are actually required to interview, right? So if an individual applies for it, you can't just blow them off. You're going to need to potentially submit a recruitment report that's signed by the employer describing the recruitment steps that were undertaken and all the results that were achieved. And then you submit it, to back to the Department of Labor. Um, and really, I think preparing for a perm audit, right, in advance is very important. Um, and what I mean by that is having a perm audit file. So make sure that at the start of the perm process, the 9089 process, you're keeping
Mhm.
detailed records of the recruitment process, the job postings, the resumes, the interview notes, any relevant documentation. Work with an immigration attorney. Again, doesn't have to be me, can be anyone that has experience with this process. And stay updated on some of the regulatory changes that might happen, right?
Mhm.
Immigration laws, regulations are always subject to change. Just keep those, in mind when responding to the perm application. So I would say really good record keeping is the key to success for responding to a perm audit.
Yes, it's very important to have all your documents right and up to date and proper copies of them so that you have some for yourself, some for the attorney and everybody working under for the whole process. And I hope you get, I mean, your perm, your H-1B, everything as soon as possible. Consult an attorney, whatever immigration issues you're facing, maybe, they can be clarified and you'll be directed in the right path. That's just it. And can you also discuss the legal implications, of material changes to an employee's job description or duties after the I-140 approval, Prashant? And how can employers, ensure compliance while addressing the dynamic nature of job roles?
Yeah. So in terms of, you know, if there's any material job changes, right? I think we briefly touched on this before. As long as the new job that you're doing is the same or similar to the one that you're originally sponsored for, then you don't
Right.
really need to worry about restarting the entire process. However, if there are material changes, right? If your new role is completely different, right? You're going from a business analyst um, to something like a product manager, program manager, right? All within IT, chances are you have to restart the perm process. If you're going to start using different programming languages than what you were originally sponsored for, right? You were
Hmm.
formerly a software developer, a software engineer, but now you're going to be a data analyst. chances are you're going to need to restart the perm process. If, however, you're going from a software engineering role to like an IT manager role where you're managing a team of software engineers, that's completely fine. That new role is the same or similar as the one that you were originally sponsored for. So those are some things to keep in mind, and even from a compliance perspective, I would say, for an employer, those are the things that they should be thinking about. Is, if I'm changing this person's job title or job role, how does that impact the process that we just did? Is this going to force me to restart it, or is this a job that's the same or similar as the one that we sponsored him for or her for? And we can, therefore keep all of our processes intact and not have to redo them.
All right. And I think another thing I want clarification for is how does a relation affect the application process, if the employer is related?
So if the employee is related to the employer, chances are that at the perm process or even at the I-140 stage, you could trigger an RFE, right? They want to know, does the employee have some sort of ownership interest in the business? They want to know, hey, is this employer just kind of doing a favor to the employee because they're related, right? So chances are those things are going to be scrutinized where they're going to ask if you as a beneficiary have some sort of ownership interest or if you're related to the petitioner. And if you are, chances are, your record keeping needs to be even more accurate, right? Did you do the recruitment? Did you do it properly? Did you interview candidates that did in fact, apply for the job, or are you giving preferential treatment to this, person you're sponsoring because they're your relative, right? So those are things to keep in mind.
Right. Thank you so much for clearing that out also. And now I have the last question, and that is, what are the best practices, for maintaining legal status during the gap between the I-140 approval and the adjustment of the status filing?
Yeah. So keep in mind that once you have the I-140 approved, you can take advantage of an unlimited number of H-1B extensions, and they're typically granted in 3-year increments. So continue extending the H-1B, continue maintaining your status until the priority date is current, and you can actually file your 485 application. Don't violate your status, right? Don't do anything that can jeopardize your H-1B. Sometimes, people do funny things where they'll work with an employer and then they'll go on the bench for a certain amount of time because the employer doesn't have projects. Try to avoid those types of employers,
Mhm.
because you should never be on the bench, while on H-1B, unless, you're taking like family medical leave, for example, like FMLA, that sort of thing. So I would say don't do anything that jeopardizes, all of the time and effort you put into getting your I-140 application approved, all of the time and effort that went into, preparing for it. It's a 2-year long process almost in some instances. But once it's approved, right, maintain your H-1B status, and do so in a way that allows you to continue maintaining that H-1B status, so that you can get to your priority date being current, and you can then file your 45 application.
All right, all the best to all you folks out there who are already applying for their I-140. I hope it all goes perfectly. And we are definitely going to take up chats now, the questions on the chats. Thank you so much, Attorney Dubé, for, you know, going through with us today. And I have this question from Najib Khan on YouTube. Approved I-140, considering new employer, new PERM process for the labor certification, and file a new I-140 petition. Can wife work on H4 EAD until its October 2025 expiry during the transition?
Yeah, absolutely. Right. So your I-140 petition that was approved with employer A, as long as it was never revoked prior to, that 6 month, that 180-day threshold that I was talking about,
Right.
all of the benefits of an approved I-140 will vest for you. So that means even when you're going to a new employer, they're filing and redoing the I-140 process for you. Your spouse can work on that H4 EAD without any issues. She's absolutely allowed to do that.
Okay. I hope you got your answer to that, Najib Khan from YouTube. Thank you. And let's move on to the next question. And Can we take up another question? Let's take it from Ravi. If an I-140 application is in process and the employee is laid off, is the I-140 petition revoked, or can that still be in processing stage? This is Ravi on YouTube.
Yeah, it's up to the employer, right? I'm sorry to hear about the layoff situation. It's entirely up to the employer to keep that I-140 petition pending until it gets approved. And even after it gets approved, it's entirely up to that employer as to whether or not they want to revoke it, right? They could potentially revoke it because they might think, well, this individual has been laid off. Um, Chances are, we're not going to sponsor them anymore. Chances are he may never come back and work for us. And if that's the case, then they don't really have any motivation to keep that I-140 intact, right? So from that perspective, if you have a really good relationship with the employer and the immigration team, it's definitely worth talking to them about and telling them like, hey guys, just keep it intact for 6 months after it gets approved because at least that allows my priority date to vest. It allows me to take advantage of the unlimited H-1B extensions. So if you can just leave the application alone after it's been approved, um, you know, that would be a huge favor to you. But again, that's entirely up to the employer.
All right. So next question, let's take this one. It's an anonymous one from a Facebook user asking, I'm waiting for the PERM labor certificate uh, since May 2023. Due to some personal reason, I will have to go to India. They have office in India, so I will be working on Indian payroll for the same company. The company is willing to continue my perm and then the I-140 process while I will be in India. Is there any issue do I have to face with perm or I-140? My H-1B is maxing out on the 31st of December. I mean, the whole thing is couldn't be displayed, but yeah, that's
Yeah.
the
No, as long as this individual has a visa stamp to come back to the US, you can absolutely travel with a pending perm and I-140 application, right? That's not a problem. And yeah, as long as you've got an H-1B visa stamped on your passport, you're eligible to come back as well, right? So just because the perm is pending does not mean you cannot travel, right? And just because an I-140 is pending does not mean you cannot travel.
all right. Facebook user anonymous. I hope you got your answer. And let's take up another one. We have a few more minutes to go. So, which one should it be? All right. So, Chandra on Facebook is asking, I have a TPS status and TPS EAD. Can I work on a site like Dudash while my EB3 skilled I-140 is processed by my regular full-time employer? So, it's like a part-time job while on a full-time job, I guess.
Yeah, yeah. Yes. So the beautiful thing about an EAD card, right, is that you have unlimited work flexibility, unlike an H-1B, right? EADs can open their own business. They can do DoorDash, for example. They can work for an employer. They can day trade, right? Like you can do 5 different things on an EAD, and there's no limit from a work perspective. So that's absolutely fine. You can do DoorDash while you're keeping your day job, so long as your work authorization is being governed by your EAD card, right? Because you do have that unlimited amount of flexibility with the EAD.
All right, Chandra on YouTube. Moving on, let's go to another question. And this one is from Tina. Tina says, hi, is it usual to receive RFE on I-140?
If there's a reason, yeah, right. I would say, probably RFEs happen 20-25% of the time. Vast majority of the cases, a favorable decision is made on them. But, you will see sometimes RFEs happen because the, the agency USCIS might be curious to know how does the employer have the ability to pay these wages, right? Maybe it's a brand new employer. They don't even have financial audit reports, right? Maybe they've not yet filed a tax return, but they're trying to sponsor someone, right? So I would say from that perspective, they might be curious, like, can you tell us your ability to pay these wages? Sometimes it can be, is the employee qualified, right? You haven't provided any experience letters. You haven't told us how the employee is qualified. What courses did they take that qualifies them? What jobs have they worked in the past that qualifies them, right? So I would say it's not something that happens, it's definitely not flipped. It's not like RFEs get issued 75% of the time. I'd say 20 to 25%. Yeah, you'll get an RFE, but it's usually because something's missing in the application file.
So, like I said earlier, keep your documents updated and keep all your documents with you. And all right, let's move on to this one. This is spouse related. So, yeah, let's take it up by David C. on YouTube. On H-1B with an approved I-140, my visa expires August 2024. I'll marry in November or December this year and want to bring my spouse on H-4. How should I plan my H-1B extension stamping and H-4 application for my spouse?
Yeah. I would say you're eligible very soon, if not already, because you can start the renewal application for your H-1B or the H-1B extension application 6 months in advance, right? So I would say get that out of the way, right? Get your H-1B approved so that you have validity, let's say from August 3rd, 2024 to August 2nd, 2027, right? Um, so get the H-1B extension done and completed. From there, set up as soon as you get the extension kind of approved and like the marriage happens, right? Um, I would say apply for the DS-160 application, get an H-4 visa stamping appointment done for your spouse as soon as you guys are married, right? Because she is going to need to show like a marriage certificate, for example, um, that to prove the spousal relationship. So I would say, work on the renewal for the H-1B extension as quickly as possible. As soon as you guys are married, set up the appointment for your spouse to go get an H-4 visa stamp. I have been noticing that obtaining visa appointments has obviously gotten better from the COVID days, like much, much faster, especially for spouses of H-1B holders. So she should probably be able to get an appointment within a month or two. Shouldn't be too bad of a wait.
It's not going to be much of a trouble for you then, David C. All the best. I hope you get it and get yourself renewed as well. And let's take up another question, and this one will be from Mithilesh, if I'm pronouncing it right. Can we file both EB2 NIW and EB3 simultaneously? Is there any impact on one another?
Yes, you can, right? So you can have multiple employment preference category applications pending at the same time, right? It can be in the EB2 NIW or EB1A categories along with the EB3 category. That's absolutely fine as long as you qualify. Nothing stops you from having multiple I-140 petitions filed in multiple preference categories. That is completely okay. There's no rule or regulation against it as long as you satisfy the requirements, right? So the EB2 NIW obviously has a higher threshold. So as long as you satisfy it, you qualify it for it, you can get an approval on it. And same for the EB3. Both can be applied for you.
All right, all right. Thank you so much. And this last question we'll take up for today is from Laura Fernandez. A priority date for EB3 change of status. When can I have it after filing the perm or after I get the I-140 approved? I am confused a little bit.
The change of status one, maybe this person's going from an H-4 to an H-1B. But essentially, you get the priority date when you file the PERM application, right? So the online filing date of the PERM application is your priority date. It is not when you file the I-140. It is not when the PERM gets approved. It is the online filing date for the PERM application. That is what dictates your priority date.
Right. Thank you so much, Prashant, today for, we have finally completed, the two episodes we had on navigating the I-140 petition. So to wrap up,
Yes.
if you have any end notes to tell the audience who have been watching us on these two episodes would be great before we leave.
Yeah. I would say, for end to end for the perm labor certification process, right? Prevailing wage determination, right? That PWD, the perm, the I-140 application, work very closely with your employer, their immigration teams, to navigate this process. Make sure you have someone on your side who is thinking 12 to 18 months out, not just at the PWD or the perm, but they're actually thinking about, hey, what's the employment based preference category that we're going to put, on the I-140 petition? Or how are we going to show the employer's ability to pay the wages? Or how are we going to demonstrate that you qualify for this position, right? Do we
Mhm.
have your education evaluations? Do we have those experience letters? And if we don't, are we going out and getting them, right? Have a trusted advisor who is advocating for you and thinking for you ahead of time, right? As opposed to all of those considerations when PWD is done, perm is done, and you're missing something for the I-140 and you're like, oh man, I think I got to go back and redo everything, right? And it's very tough to get those 12, 18, 24 months back, right? So that's what I would advise is always have someone that's thinking 2 years ahead of time for you.
All right. So thank you so much. Definitely go talk to an attorney, get your advisors, and consult attorney Prashant Dubey as well. Write to him at info@dubeylawoffice.com. And you can also mail me as well at nipa@higheritpeople.com. And my phone number is also displayed on the screen, 408-335-6444. And you can visit our website at www.higheritpeople.com. And once again, thank you so much, Attorney Prashant Dubey, for joining us today and wrapping up this episode on the I-140 navigating the petition. Thank you. Have a great day ahead.
Thank you. Take care, guys.
Thank you. And folks out there, thank you for joining us once again on this episode today with none other than Attorney Prashant Dubey. Check us out, subscribe to us. Don't forget to hit the bell icon. And, thank you for joining us today. You can always write to us. And, we deal with immigration related content. So stay updated on the latest developments and the best practices. And we even give out tips and everything. So I'm sure you are going to love what we share. So Immigration and Jobs Talk Show it is. And call us on the number 833-412-8472, or you can even mail us at support@higheritpeople.com. And definitely don't forget to visit us, our website, www.higheritpeople.com, because, we deal with EADs, visas, and then H1B, the E3, and everything else. So, everything related to immigration and jobs and visas, this is your stop. Thank you so much for joining us today. It's Nipasa Pradhan saying bye bye for now. Have a great Friday, a fun one, I hope, and I'll see you again very soon. Stay tuned. So, bye bye.